Thank you, Nigel. Afternoon, everybody. A lot of what we were planning to do was uh, in the early parts was actually explained to you by the previous speaker. So we are going to cycle through a lot of the early slides. So Gary, you going to drive for me? Uh, no. Oh, okay. I got the clicker working. Yeah, okay. Good.
Yes.
All right. Okay. Um, so that's me and Bartlett. Background. I'll put that slide there. What we're talking about here is about online data privacy, and it's about what is known about you by the purveyors of online assets, websites you visit, services you consume online. Every time you go online, you leave a trail, and a lot of user data is tracked. Some of it is described as personally identifiable information, PII. You will see that several times. You've seen this definition before of what that is, personal data. That's one by the National Institutes of Science and Technology, NIST, and that's the one that practically most of the US regulatory organs tend to adhere to. Two things you should notice about that, and the previous speaker spoke about it. It's not just about the data in clear form that is your personal identifier. It's also data that, if you look at it in summary, bits and pieces they put together could be used to identify you. So that is called linked data. So remember the two concepts, linkable data and linked data. Um, that's the definition for GDPR. And you will notice from the previous speaker that a lot of the controversies surround definitional elements so of personal data, what personal data is. But it's quite wide ranging. What it does, though, is that it sets up a kind of conundrum for us in the Caribbean here, because depending on where you are and what you're looking at, then the definitions become important. So, for example, we have a situation where we get European tourists, and if you are a hotel and you collect that data, you become a data controller under the law. If you look at the elements of that data, that could get you into confrontation with a DPA, Data Processing Authority, Data Privacy Authority, in a European country. It's a lot more extensive than if you look at the American definition for what that is. And you have to be mindful of that. Here's a problem. We use operating support systems, all the front office systems that you have in hotels and so on. Where do they come from? Tend to come from the United States. So you collect all of this data and you become a data controller by virtue of the GDPR if you are a European citizen as a guest of the hotel. And then you run into questions of what it is that you're covering, what is it you're collecting, and so on. So it's very important to understand the distance between the definitions in both jurisdictions. It is the definitional issues that largely will fuel a lot of the dueling you see in the data processing world, especially as it relates to the Caribbean context. I want you to remember that. Just today, there was a New York Times article that actually did a lot to kind of underscore what I'm saying. It had two of the reporters. One, under the law, the data controller is required to tell you when asked all the data they have about you, and they have to disclose it to you. And they had one situation where the disclosure was asked from a US perspective and disclosure from a UK perspective. And it was interesting to see what came back from both perspectives for the same person. It's important to get that. Okay, so that's the bounding principle. It's the right to privacy. The right to privacy existed for quite a while. Some of it is in constitutional law, in the Constitution, and some of it is legislation and their regulations pertaining. It's very important for you to understand that it's as early as 1980, there was talk about rights to privacy and how personal data is connected to that right. From as early as 1980, OECD, Organization for Economic Cooperation and Development, that is the top 25 economies of the world, they actually put together a right for privacy and transfer of data that speak to that. And then going through, you have the UN human rights law, and then you have the rights for political and protected persons. All of these international treaties, if your country signed one of those treaties, they're obliged. And even if they do not have the national legislation to put it in place, they are obliged under those treaties to consider your privacy. So it's not a new thing. It's just a different dimension to it that we're talking about. You've seen those principles already, so we won't go through those. They're all there. What is important about the principle is that you use the principles to determine the soundness of the law. So wherever you have data protection law, they tend to be examined, they tend to be characterized by looking at whether these principles, which are long established principles all the way from the UN intervention to OECD intervention, that will tell you whether or not the law you have is fit for purpose. So you're aware of that. Processing personal data, there's principles associated with that. And you notice the previous speaker spoke a little bit about that. But those are the ones that you must remember. And no matter where you are, those principles apply for processing personal data. If you're a data processor, data controller, it says individuals must give consent. That's very important. It is part of a contract. It's a legal obligation, etc. Those things are important. Here's the thing about giving consent. In current GDPR instance, it says that if you have to give consent, if getting a service is contingent on you giving consent, then that consent is not freely given. Think about that for a minute. If you have to get a service, and to get the service, you must give consent to have your personal data processed. And process in this case mean everything from collecting it, displaying it, storing it, anything. That's what it means. It's the definition of process and the meaning of process is extensive. But it says consent cannot be coerced in order to get a service. And that's the real problem for those of us who think about business and how you do it. So now I'm going to call on Bartlett. Bartlett? Bartlett, you available?
Hi, Carlton. Are you hearing me? Hello?
Bartlett?
Am I being heard?
Yeah, let me tell you a little about Bartlett. Bartlett, as tell you, is a lawyer. I asked Bartlett to come with me in this because a little while ago, I tried to talk about this, the data protection law, and an attorney at law accused me of giving legal advice without having a law license. And they were concerned that I was giving away what they bill for free. So to protect myself, I don't know what it is like in this jurisdiction, but to protect myself, I have asked Bartlett, who is a bona fide lawyer, my protege, to assist me with that and give me coverage. So Bartlett, take it away. Bartlett? Bartlett, you want to get me in trouble here? You're not abandoning me, are you? Message him. Huh? No.
Hello, am I being heard?
Yes, Bartlett, go ahead now.
Excellent. Okay, so sorry about that slight glitch. So first of all, thank you everyone for having me. I'm really pleased to have this opportunity to share the stage with Carlton, just to kind of, I think, really provide some necessary context. Because I mean, given everything that's gone on with the impending GDPR and so on, privacy has become far more topical, and I think very often we get ahead of ourselves considering what obtains perhaps in Europe or elsewhere without first considering what we have or don't have here in the region. Now, having said that, what I'm hoping to do in these few minutes is really just to kind of lay the groundwork and sort of give you a sense or a taste of what we have here in the Caribbean. Now, at its broadest, at its very broadest, in the Caribbean, we have 32 different territories. I mean, it sounds like a lot at first, but when you think about it, there are literally 32 different countries, well, not countries, but territories here. And what obtains in each is slightly different. Now, as a first starting point, I think what we have to consider broadly is something that was touched on a prior slide, which is the overall framework. It starts with the constitutions in the countries. And one of the things you'll find is that not in all, but in most Commonwealth Caribbean countries, or even outside the Commonwealth in the Dutch Caribbean and so on, when you look at the constitutional instruments that apply in the jurisdictions, you will see some recognition of the right to privacy. Now, the challenge with that is, in real terms, that right is really only actionable against the state and state actors. And so, in a real sense, it's very limited in scope. And so, if, for example, you're in a particular jurisdiction and there's no substantive privacy act, it may be that if another third party who is also a private actor breaches what you perceive to be your right to privacy in a situation, you may not have direct recourse against them, depending on the jurisdiction you're in. And so obviously it's challenging in that way. And obviously also just thinking practically, if you get the theory, if you want to bring a constitutional motion, that's a very expensive and time-consuming process, simply because somebody sold your email address to a third party. It may not be worth it in that sense. But having said that, though, depending on the state you are in the Caribbean, if you are within what we call the Commonwealth Caribbean, then the common law and the common law principles would apply. And that comes with certain things, because there are certain common law rights that have developed over hundreds of years, which sort of were seen to be dead, but have been revived in the past, maybe 15 years, and have been refashioned as tools to protect the rights, privacy rights of persons when there's no substantive legislation. The first one that comes to mind is intrusion and seclusion. It's what many people refer to as the invasion of privacy, right? Loosely, it sort of resurfaced in Canada maybe about 3 years ago in one of their court of appeals. But and the details don't really matter. But the point is, the courts have fashioned this as a remedy, and also more of you would probably be familiar with the duty of confidentiality. And long story short, all that says is, if I am providing information to you in a context where it's clear from the context that the information should be treated confidentially, you shouldn't then go and release that information to a third party without my permission. A classic example is your doctor, or someone like me, your lawyer. You can't come and give me information. It's clear from the context that that information is more than likely confidential. And then, I, without your permission, just go and share it with a friend of mine over drinks. But the problem with the common law rights as well is similar to what happens with the constitutional right to privacy, which is that even though this one is actionable against other private individuals, the challenge is it's expensive and time consuming to pursue. And so in a way, those kind of, I guess, sort of made the case for why it's important to have substantive privacy legislation. that establishes the right broadly and allows mechanisms for enforcing it. And a lot of what Carlton would have mentioned earlier, and even the prior presenter, those principles, I think they're very important because as Carlton mentioned, it's those sort of well accepted principles, that were initially fashioned by the OECD that we've sort of come to use to sort of more or less assess what's going on in a particular jurisdiction relative to whatever legislation they may have in place. Now, having said that, the slide, which I believe is on your screens now, I don't know if Carlton's slide is still up, but it should.
No, the panoramic view is up, Marston.
Yes. So, as regards the panoramic view, so one of the things you'll notice there is that of the 32 territories in the region, you can classify 24 of them as being CARICOM/CARIFORUM states, or states that are affiliated with it, or have observer status, for example, in CARICOM or CARIFORUM. And of those states, exactly half of them have legislation, and the other half they don't. It's actually similar when you go outside, because half of the states have it, and the other half they don't. And obviously, this is perhaps an overgeneralization because there's a lot of nuance, which I think is sort of important to capture in this conversation as well.
I'm putting up the Excel spreadsheet.
Excellent.
Bartlett.
Excellent. So if you are on the sheet that says what we've humorously labeled the privacy shootout, and you go from the top left where you see Anguilla and then go to the cell beside it that says privacy legislation, you literally see X's and ticks to denote where there isn't or is privacy legislation. And if you were just to slowly scroll down that column, you would notice the countries that do have and those that don't. So for example, Anguilla doesn't have express legislation. Antigua does, Aruba does, the Bahamas, Belize does not, Bermuda does, the BVI, they don't as yet. The Caribbean Netherlands have legislation in place. The Cayman Islands has in place, although it hasn't come into effect yet, they do have it in place. Cuba doesn't have an express legislation that deals specifically with it, although, obviously, as I mentioned earlier, their constitution, for example, would cover the right in a broad sense. Curacao, they've put legislation in place. Dominica hasn't gotten there as yet. The Dom Rep, they have legislation in place. Grenada, they're not there as yet. Guadeloupe is there. Guyana, Haiti, Jamaica, they all haven't reached there as yet. Although with the case of Jamaica, this would be an interesting segue because one of the things we should note is that there are countries who are making efforts to get their legislation passed. And Jamaica is one of them. They've been making a lot of headway recently, and there's now ongoing debate and consultation with civil society to get their legislation through the gate. Interestingly enough, Suriname, where we are now, well, most of you are, actually, I think, tabled their privacy bill earlier this year, maybe about a month ago. And so all things being equal, they should perhaps in the foreseeable future be in a different column when we revisit this perhaps down the road. Now, the thing though is that what we've observed is that simply drafting legislation very often may not be enough because as we can tell from the case of, for example, Barbados, the legislation was drafted and made public since 2005. And perhaps 13 years later, there's still no legislation in effect. And obviously, there's no point in drafting it if you're actually not going to enact it, given all the benefits which we can wax poetic on about passing the legislation.
Back to the slides.
Yes, so.
Slides.
So yes, if you were to go back to the slides now and just briefly look at, for example, the next slide, it's the next diagram which we Well, because one of the things we recognized in doing this presentation was that there are no truly neat categories to place the entire Caribbean in. You know, a lot of the categories that we place countries in, they tend to overlap with others and so on. And so we did another slide which shows you, based on primary language, that kind of a thing, how the legislation is panning out. And so we see where in the Dutch and the French Caribbean, significant headway is being made, in terms of passing legislation. And as I mentioned just now, the only Dutch-speaking territory without privacy legislation is actually Suriname, and they are making headway, have been put forward a draft bill in Parliament. Clearly, well, the US territories, they don't have Puerto Rico and the USVI. They don't have a specific act that is a broad-based, all-encompassing act that covers privacy. However, they do have legislation that speaks to breach notification, which is a specific aspect of privacy and data protection, but obviously not the full story. Now, obviously from this slide, it's clear that those territories in the Commonwealth Caribbean, the mostly English-speaking countries, seem to be the most recalcitrant as regards getting legislation through the gate. Now, one of the things we did was just to sort of make this more practical as an exercise, was we actually put together a list of some of the territories from the region, and we looked at their legislation bit by bit, just to see, as regards some of the fundamental principles that were discussed earlier, which ones have actually put them into effect in the legislation that they have on the books. And so for that exercise, we would have chosen Antigua and Barbuda, the Bahamas, Bermuda, the Cayman Islands, St. Kitts and Nevis, St. Lucia, and Trinidad and Tobago. Now, the categories we used just to sort of more or less assess the situation on the ground was the definition of personal data that the individual jurisdictions went with, the appointment of a data authority, the provisions for fines, cross-border limitations, and whether or not breach notification is an aspect of the law on the books. Now, one of the first things I wanted to sort of just go into just a little bit was this notion of the definition of privacy and data protection. Now, for me, this was particularly interesting because one of the things that you wouldn't expect to, but did turn out to cause significant variance, is in how each territory approached defining it. And so, for example, in Antigua and Barbuda, they have a definition of personal data, but one of the things that jumps out about their definition is that it's limited to commercial transactions. And this is also the case with St. Kitts, who just passed their act, actually, I think a week and a half ago, more or less. So they're very new on the scene. And their definition also limits personal data to information that is in regard to commercial transactions. And obviously, I mean, it's fairly subjective, but to my mind, this may well unnecessarily limit the ambit of the acts and the amount of protection that's afforded to everyday people under the acts. Now, Bahamas, which we all know was perhaps first out of the gate. I mean, I think they would have passed their act as far back as maybe 2003. They have limited their definition of personal data to only living individuals, which I find to be a fairly interesting one as well. Now, in the case of Bermuda and the Cayman Islands, who are now, pretty much just pushing their legislation out, and I think in the case of the Cayman Islands, it doesn't actually take effect until 2019, but they passed it and it's on the books. They along with Trinidad and Tobago, they made what I deem to be a critical next step, which is that in their legislation, they not only define personal data, along the usual lines, which is, stuff to do with your physiological, genetic, information, expression of opinions, the usual things you tend to see in all of these bits of legislation. But they also added a second category for sensitive personal data. And this is particularly important because obviously if the data is sensitive, and this was touched on in the prior presentation, the key thing is if the data is considered to be sensitive data, it means then there's a greater risk that in the wrong hands, it may be used to discriminate against you. So things like sexual orientation, ethnic origin, matters of that nature, those are deemed to be sensitive data. And what those legislation, those acts do, the one in Cayman, the one in Bermuda, and also in Trinidad, what they do is that they treat to sensitive data slightly differently. And in my view, it's fairly significant, and it's a positive step, which in my estimation ought to be sort of followed by those jurisdictions that haven't as yet passed legislation but are looking to pass it. The St. Lucia, they attempt to do something similar. So when you read the St. Lucia definition of personal data closely, they attempt to do the same thing. But the problem is they then went and conflated sensitive data with regular personal data. So in other words, even though it was a lofty aim, by virtue of just simply putting it in the general definition of personal data, you sort of lose the special protection that's guaranteed to persons when their sensitive data is in question. And just to touch on again this whole notion of the very limited ways in which some of the jurisdictions have defined personal data or the scope of its application. In my estimation, using commercial transactions as a means of limiting the scope doesn't help as much as it perhaps harms everyday individuals, because then it means then that if you are simply, let's say there's a social media site, for example, and they take your personal data and misuse it, as was the case, for example, with the whole Cambridge Analytica fiasco. In the context of those jurisdictions, like St. Kitts, for example, it means then that there would be no recourse for you, even though most persons, I think, would accept that as a reasonable breach of your data rights, So I think those are challenges which we have to perhaps take on board in crafting future legislation and so on. The other aspect of it was the question of the appointment of an authority to enforce the provisions. Now, as you'll notice from one of the slides there, effectively all the jurisdictions have somebody who is conferred with authority under the relevant legislation to enforce the act. Some legislation refers to the person as the data commissioner, some refer to it as the information commissioner. It matters not. The bigger point is that they all have the requisite office in place by virtue of their statute. And what this means, and this kind of ties back to what I was saying earlier about the common law and the constitutional right to privacy and why they may be limited, is because it's so hard and expensive and time consuming to enforce. Whereas when there is a data data commissioner, it means that enforcement, certainly the initial stages of your rights or protection of your rights is maybe as simple as writing a note or a letter to the data commissioner to say, I provided my data to this person in these circumstances for these uses. I believe that they have breached it, investigate. And that's a letter that takes you 10 minutes to write and costs you nothing, versus without having this legislative framework in place and then having to call up your lawyer who then charges you a hand and a foot just to take the call, to then bring litigation, which runs about 3-4 years of your life, and a huge sum just to sort of secure that same right. And so I think in these practical ways, we see the value of the legislation. And so without belaboring the point, I think it's perhaps, given our time constraints, it's probably a good idea to look at the next issue of fines. Now, I find this to be particularly, I find this to be, no pun. So the issue of fines is particularly noteworthy because I think based on what we've seen in the legislation so far, it more or less reflects the degree of importance that the particular jurisdiction gives to breaches of your rights, as regards your privacy. And so what we've noticed, though, trend-wise, is that the newer countries to pass legislation, the more recent passages of privacy legislation in the region, they've enacted bigger and bigger fines. And so what we looked at was just the maximum fines that could be levied under the different acts. And there's actually a slide that speaks to this. So if you look at the maximum fines that are levied, on that slide, you'll see that Bermuda and Cayman, which are, well, technically they haven't fully passed it as yet, you'll realize that their maximum fines are extremely significant. Now, compared to St. Lucia, and by the way, all of these figures are in US dollars, just to kind of, present a level playing field. The fines in St. Lucia, for example, or even the Bahamas are relatively limited. Now, Trinidad barely even makes the chart, but I should add that there's an exception there with them, because in Trinidad, they sort of foreshadowed what eventually came to pass in the GDPR, in that they allow fines of up to 10% of your turnover as a company. So which is actually far more than under the GDPR, which is 4%. And then under the GDPR is further capped, because if you get to, I think, 20 million euros or thereabout, then it's capped there. But there's no cap in Trinidad, and it goes up to 10%, which is fairly significant. So in that way, this chart, the chart that shows the maximum fines, may actually be slightly misleading. And in some ways, arguably, Trinidad has the most harsh or severe penalties in place. But obviously, one of the practical challenges with Trinidad is, as some of you may know, although the act has been passed, the particular provisions that actually give life to it and give teeth to the protection of the rights to privacy in Trinidad, those haven't been passed as yet. And so, in a way, on paper, as you'd see here, although there is the legislation, there is no means of enforcement in Trinidad as yet. And so, although some would be perhaps impressed, I certainly am, with the fact that they've gone this route to ensure that people get the message that protecting data is important. Obviously, it's sort of not very different from those jurisdictions who have spoken about privacy and data protection and the importance of it, and they've even drafted a bill, but they haven't actually passed it into law. Because at the end of the day, if you don't have the protection, it doesn't matter which stage you're at in the process. So I think the other issue I'd want to touch on quickly, I'm not sure how much time we have left, is the whole question of breach notification. So what you'll notice, if you go to, if you go back to that slide, you'll realize that this is one area in which we haven't sort of gone as far as we perhaps should have, and perhaps this is a missed opportunity again, because if you look at it, only Cayman and Bermuda, who are yet to be sort of come out of the gate and are in time the newest, only they have considered breach notification as being significant enough to place it into the act. Nowhere else in the region, as far as I've surveyed, has equivalent provisions in your legislation. And then obviously the practical challenge with that is, if there is a breach within an organization and the personal data of its users, of its systems, for example, are compromised, if there's no obligation to tell anybody anything, then effectively, what then is the point of having an entire privacy and data protection legislation and an enforcement regime if nobody knows that there's something to enforce? So in a way, without having the notification requirements, it sort of makes it, remove some of the teeth from the overall impact that the legislation could have had. And so obviously for future rounds, when legislation is being amended, I would hope that this is a consideration that's taken on board. Which leaves us with the final major consideration here, which is cross-border limitations. on the transfer of data. So this was discussed earlier to some degree, so there's no need to go over the the definition of it and what have you. But what I would say is that obviously if you don't have any kind of mechanism in place to limit it, then what this does is it creates a situation where persons can again sort of bypass the framework that you put in place. So what happens? So then if you can simply just send off your data to be processed elsewhere, and there are no correct, high standards or meaningful standards in the jurisdiction where you're sending it off to be processed, then if something goes wrong, there's no real recourse for the data subject whose data has been breached. And again, it sort of raises a practical question, why go all the way to pass the legislation if you wouldn't sort of consider protecting the data subjects as reasonably comprehensively as you could have otherwise? And so obviously that's an area I think we need to perhaps look at again, if perhaps there's a next round of HIPCAR related reviews and recommendations. Perhaps these considerations need to be given greater prominence in that regard. Now, I think in large part, this covers the major considerations, based on the different acts that we've looked at. And so I wouldn't wish to belabor the point very much further. And so at this point, what I'll do is I'll simply thank you for having me. And I'll open the floor, I guess, if there are any questions or if there is time left for questions.
Thank you, Bartlett. The questions that we want to go around is that the slide is up there. There are some issues that we must contend with. Law comes out of sociocultural considerations, developing laws. So, for example, if you look at the European law, it is largely impacted by the German experience, and the German probably national laws are probably most stringent in concerns to some issues, for example, of sharing data, and they have provisions for hate speech, hate laws. They have provisions for sharing data among hate groups and so on, special provisions and so on. It's part of the sociocultural mix of it. We see some of that that came into play in our area recently. You might want to think about the dependencies. One of the things that the HIPCAR, I don't know how many of you remember the HIPCAR thing. One of the things the HIPCAR did was it was engendered by what is called the EPA, Economic Partnership Arrangement. It had a whole set of laws that they looked to include and upgrade, but there were contingencies. There were contingent connections between them. So, for example, you have data protection, and you have cyber crimes, and you have interception of communications, and so on. But they developed a really good framework for how these laws should be developed. But they developed some model legislation that put away. It's a good place to start. Look at it again and see what is there, because it does have, especially in the data protection area, they do have some interesting things to show you. You might want to go back to look at the IPCAR outputs, the assessment outputs, to see how they impact here. The other thing is the political considerations. I can tell you just about everywhere in the region, there are some clauses that give concern to some groups, mostly the media people. For example, in Jamaica, the Section 37 of the bill that's now before the Joint Select Committee. The contention is that we have whistleblower laws, but the law as is written in the bill now would not protect journalists from disclosing information that may be given to them from internal sources. There are exemptions in the law in terms of public authorities. So, for example, there are cutouts for national security interests. National security interest is broadly defined. It could mean anything the minister says it means. And those kinds of considerations, there are issues with processing of data. For example, the way definitions, again, definitions are very important. So for example, if you look at the way definitions about sharing things and definitions of links, hyperlinks in the digital space, those definitions are very, very important to what obtains. You want to look at the law and see how those things happen. So I'm leaving you with this so that as you look critically at the data protection regime that's coming in your country, just go back and look at the principles and see how the principles are covered in the law. And then you look at some specific things that might be social cultural related, that if you look at how we would view it in our region of the world, it might be a little bit different from how it's cast elsewhere. But it's a lot to take in. We have to end it here. If you have any questions, I'm sure Bartlett and I would be willing to accommodate them. Yes, Deirdre. Yes, I can hear you, Dee.
Since we're talking about data protection, on the footer of Greg's slides, it said confidential. Is it?
Well, it may be that Greg was thinking it was confidential. Probably lawyers tend to do that. Everything is confidential until they tell you. I don't think he meant to say what he was disclosing to us is confidential. Or maybe it's a way for him to get around the issue that I brought up, where I am talking about law and what I say might be construed as advice. And since I'm not a lawyer in some jurisdictions, they might have me up for practicing law without a license. So maybe that's a cover for that. Any other question? All right, thank you all very much.